Hear ye, Court of Appeals for the First District of Texas now in session. Pursuant to adjournment. God save the Constitution and the court.
Good afternoon and welcome to a virtual session of the First Court of Appeals in Houston, Texas. We have two cases on today's docket. Cause number 0119000580 Thomas Gunnar Kelly versus Sherry Marie Kelly, and cause number 01210015-CV Weeks Marine Inc. versus Mario Carlos. We will call Kelly versus Kelly as our first case. And when that is done, we will move the attorneys in that case out of the Zoom conference, and we'll move the attorneys from the second case, Weeks Marine versus Carlos, back in. So may I have the appearance of counsel in Kelly versus Kelly for the appellants first, please.
Your Honor, I'm Denise Smith for the appellant Tom Kelly, who is the husband in this marriage.
And how much time are you reserved for rebuttal?
5 minutes, Your Honor.
5 minutes. And for the appellee?
Haley Burnside for the appellee Sherry Kelly, Your Honor.
Okay, thank you very much. We will see Mr. Morrison and Mr. Levitt in about half an hour. Ms. Smith, you may proceed.
Thank you, Your Honor. May it please the court. Your Honors, my name is Denise Smith, and I represent the appellant Tom Kelly. He was the husband in the case below. And this is an appeal from the trial court's property division incident to divorce. There weren't any children of this marriage. There's a lot of error in this record, and the math doesn't ever compute. It was objected to before and at entry, but those objections were ignored. Instead, there was a rubber stamping of what Mrs. Kelly asked for. In oral argument, I'm going to focus on the errors that were the most financially costly and egregious, unless this court has particular questions on other matters, which I'm always happy to answer. Your Honors, I'm bringing 2 points to the court today, and that is the first point is that the trial court ignored all of husband's separate property except his house. And a lot of this, most of the separate property or all of the separate property I'm talking about was earned well before the marriage. Instead, this trial court divided up a marital estate that included husband's separate property. My second point, which is related certainly to the first, is that the awards by the trial court said it was awarding 60-40, 60 in favor of Mrs. Kelly, the wife. That's really not what happened. The math by any computation favorable to Mrs. Kelly is that it was 64-36 of all assets, including separate. And we're also saying that a lot of what happened and the way this trial court divided up the marital estate was a backdoor sanction for alleged discovery abuse that happened months before trial.
What is our standard of review on this?
Your Honors, the standard of review is abuse of discretion. Admittedly, that is a very broad standard. However, when it comes in the discretion only has to do with community property. A trial court has no discretion to divide up separate property. And in fact, anytime this court were to find that the separate property was included, harm is presumed and a remand is required. Unlike other areas of the law where we can do a rendition on certain matters, that's not permitted because where the entire marital estate that was being divided up included separate property, then it has to go back for a recalculation of everything. And importantly, not only is separate property is protected, not only in the family code in section 3.01, but it's also protected under the Texas Constitution.
So what are your best points for what's separate property here?
The best points for separate property certainly are that the 401k that Mr. Kelly had and he brought into the marriage, that a good deal of that was separate property. And instead of separating out or taking off the top Mr. Kelly's separate property, the trial court divided the entire 401k. And to add insult to injury, the trial court didn't divide it 60-40. The trial court awarded 78.65% of the total balance of the 401k, including separate property.
Here was Tom's testimony sufficient to establish some portion of the 401k as separate property?
We believe his testimony would have been sufficient because it was uncontradicted. Had it been uncontradicted, the court makes a great point. However, not only was it uncontradicted, we have documentary evidence that came in through the expert, and we have a forensic expert who was a CPA who testified based on the AIG documents exactly how much was in the 401k to the day of when they got married on November the 6th. So the important point is this trial court gave Mrs. Kelly over 78% of a 401k that a great portion of was separate property.
And if we determine that a portion of this 401k is in fact separate property, then what would be your position on what happens next?
Your Honor, the case law is clear across the state, including from this court and the Supremes, that a remand is required. And I'm sure it has to do with the fact that when you take a full amount and you say, okay, we're dividing this up and here's how we're dividing it, that we have to go back and look at everything again. So I frankly was looking for a way for rendition because I do a lot of other civil law and I was trying to save my clients some money. But the fact of the matter is, all the case law is really clear that if this court finds that any separate property was awarded to Mrs. Kelly, that a remand is necessary. Again, I was trying to save us all some time and my client money, but that's really not the case. We talk about this in depth in our standard review section of our appellant's brief. Again, I was looking for a way for rendition.
Sure. And also, I had another question about this may be where you were going next, but the severance package. What is your best authority for why any portion of that would be separate property? Because it does seem like here there's a huge discrepancy between what he would have gotten if he hadn't signed the agreement versus what he got because he signed the agreement. So why isn't this a payment? Why shouldn't we consider this as community property? Because really this is about his decision to sign the agreement.
It was about that decision, Your Honor, but it was also based on weeks. The weeks of severance were based on his years of service. Had he only worked at AIG for 6 years during the marriage, it would have been 6 times the weeks that he was offered. And unlike the Henry versus Henry case, that has been cited in the briefing and the Worrell case that it was based on. In both of those cases, if you look carefully at the language of those cases, in both, it wasn't really clear whether this was just based on we're giving you severance, thanks for playing and so forth. And I think it was Worrell, they said there was some evidence that it could have been based on years of service. Henry was not clear. There wasn't a clear document like we have at page 28 of our brief, which was Plaintiff's Exhibit 9, that says clear out, here was your start date, here's how many weeks, here's how many years you worked, here's how many weeks of severance you're entitled to.
But he didn't have a right to any severance. He didn't have a right to any severance at all until he agreed to enter into an agreement to you're not pursuing any benefits, or he had to sign the release in order to get it, right?
Yes and no. As I recall, I think if he didn't sign the release, he got like 2 weeks, kind of thing. Right. So
the release, the signing of the release, is what with AIG buying the piece. That is what was. That's what triggered the right to the money. It wasn't his years of service. I mean, they had to use something to calculate it, right? So they just calculated every years of service. But it's not like the rights accrued year by year.
Well, and with all due respect, Your Honor, I disagree with exactly how the court is saying it, in the sense of, you're exactly right on that he wouldn't have been entitled to any severance unless he signed, and that happened during the marriage. But how much severance that he was entitled to is completely based on how many years he had already served.
But you don't have any case, sorry.
Was that, is there some contract that says that, or some employee handbook, or was this something that was devised ad hoc in that particular moment?
This is something that AIG generated. This wasn't something that Mr. Kelly generated. The P9, which is at page 28 of our appellant's brief, is something that they sent out saying, here's your package, here's how much you're going to get. Importantly, also attached to that were several pages of, please read this, you've got to know this. And interestingly, Mr. Kelly, if Mr. Kelly had gone back to work at AIG, they said your severance is going to stop if we give you your job back. So this wasn't an absolute, you get all this money and it all happens during the marriage. It only was based on how many years he had served. Again, Your Honor, if he had served 6 years, then he would have gotten a whole lot less in severance. And we're completely admitting that the 6 years that he served, that absolutely was community property, and Mrs. Kelly should have gotten her part of it. Nonetheless, she didn't get just 50% or 40%. She got over 78% of it. Your Honor, I see that my time has expired. I'll wait for rebuttal and answer whatever questions this court may have.
Thank you.
Thank you.
May I proceed?
Please proceed.
Let me begin with Justice Ferris's question. You basically asked with the 401k, why is this evident? What evidence is there that that 401k was separate? The answer is none, except for Tom Kelly's testimony. My opposing counsel, Ms. Smith, mentions his expert, Ms. Osina. She did testify, and she did testify to what that $213,000 number was. But through her testimony, through my cross-examination of her, it was revealed that she's relying on what Mr. Kelly is telling her. The spreadsheet that he had that had no indication of where it was from, that he was relying on, I believe it was R8B, that he had come into trial with that day. She had received that from Mr. Kelly. It was all through him. So that's why the testimony is just through Mr. Kelly. He came in with no statements, no documents, no corroborating evidence whatsoever.
Well, I had a question on that. So under Texas case law, isn't it true that if you have uncontradicted testimony from one spouse, that can be enough to establish separate property? I mean, isn't that what we're relying on for finding the car to be the separate property of the wife here? Why doesn't that go both ways?
Well, Your Honor, I would say that it was highly contested at trial, and that we did not agree that it was separate property. It was on my client's inventory as 100% community property. She testified that she was asking for the court to use that number. It was contradicted, and we certainly weren't stipulating to that amount. And
did she testify that there was no money in that 401k before they were married?
She did not testify as to any amount. She acknowledged that she knew he had mentioned he had a 401k, but there was no acknowledgement on her part whatsoever of how much money was in there, whether it was funded or not.
Well, that's what I'm trying to look for. Is there contradicting evidence that that no portion of this was separate property? I know that she included it on her list, but was there actual testimony to establish that no, he didn't actually start funding this 401k until the marriage?
No, I mean, she just didn't have the knowledge to be able to contradict it. And it was his burden to be able to put forth that evidence that the court could rely on. It's presumed community property, and it's his burden by clear and convincing evidence to show the court, look, this is what portion is my separate, and here's the documents to prove it. But it was a contested issue at trial heavily. it through, but my client, she just didn't have the knowledge of the financial estate to be able to come in with a different number or anything like that. I mean,
Did he not produce any statements prior to the marriage of the 401k balance?
not one, nothing, zero, nothing. We just had his word for it. And a makeshift looking spreadsheet that he had that had no indication where it was from. And the court balanced all the evidence and found that he did not meet his burden of proof, which was only his burden of proof. It was no one else's.
I thought that the trial court admitted a document purportedly from Transamerica that reflected a balance of $213,000 approximately on the date of the marriage. Didn't that come into evidence?
It is in evidence. The court did not. So they introduced it through Miss Osina, and Miss Osina said that she had received that document from Mr. Kelly and that she was relying on him, that that's where it's from. And so there was some redirect by my opposing counsel, Miss Syed, where she said, well, are you familiar with these kind of documents? And she was like, yeah, it looks kind of like the ones that they normally have. I'm summarizing, Your Honor.
But it was ultimately admitted then, right?
It was admitted, but then ultimately in the court's finding of fact, after she reviewed all the evidence, found that that was not a credible statement. That was a finding by the court that she specifically found that he did not meet his burden of proof and that he did not provide an official, reliable statement to prove the pre-marriage balance. And I'm happy to answer more questions about that, but moving on to the severance, this was also a question I had written down for you, Justice Ferris, of why would that be considered separate property? And it just isn't. This has been decided already by Henry v. Henry, this kind of severance. He had to sign that release to get $1. He would have gotten nothing unless he signed that release. And this is the exact same argument propelled by the parties in Henry v. Henry.
So I had a question just to follow up on that. I agree that those are good cases for you. Would it be your same position if, say, they had gotten married the day before, and then he's presented with the severance agreement? Does that change the calculus at all?
No. Yep. She would be 100% community property. A very lucky lady if that happened to her. But that's what the law is, and that's what we're relying on, and that's what the court had to rely on. That is this kind of severance. The court makes this, in the opinion of Henry v. Henry, it makes a distinction of that there's a release here, and it's not a retirement right. He had no right to that severance. He had to sign that release, and that is the distinction that is important here. It doesn't matter that it was based on some formula. That's what Henry v. Henry said. The exact same argument is made in that case, and it lost, and the same one that they're making here today. So that is why it should be 100. And more importantly, before I pass right by it, there was no argument really that this was separate property, that there was a separate property component at trial. So really, this is all happening for the first time on appeal, because it was not on his inventory, which was a big issue that I pointed out. I was like, why is this not here? And it was an issue throughout the case that he was not acknowledging that this was an asset available for division. And he wasn't even acknowledging it was separate property. He just was pretending it didn't exist. And then that was an issue at trial that we dealt with. So he didn't argue that it was separate at trial. Now it is.
So can we move on to the E-Trade account and the fact that there was evidence that the husband had put in around $23,000 to start that was his separate property. And I think there is a presumption that when the funds are commingled, that community funds are withdrawn first. So then why is it that the $23,000 isn't credited to him?
Are you referring to the Bank of America, or is that what I might be misunderstanding? He did make a claim.
There's an E-Trade investment account that he apparently transferred his own funds into this E-Trade account. I can probably point you to the place in the divorce decree where this appears. As I recall, that he did make some kind of argument with the E-Trade, but it stems from this Bank of America. Mr. Kelly,
argued that he should get his pre-marriage balance from his Bank of America cash account, which had gone through transfers and all kinds of things. That account was not traced. He did not provide all of the statements throughout from the inception, and which you have to do, because if that account at any point fell below, if it fell to zero, there's no separate property, because just because you spend community property doesn't mean that the account didn't get low enough to spend the separate property component also. And I believe,
whose burden would it be to show that the account never dipped below 23,000?
he has to prove what is separate property by clear and convincing evidence. It's his burden, especially with cash. When you have a cash account, if you come into the marriage, I have $20,000, which I believe is around the number he was claiming. It's like, okay, where's that $20,000 now? You have to show the court where that money is. You don't just get to walk into court and say, oh, I had that money before and I think I still have it now. No, you could have spent it. And I believe through my cross-examination of Mr. Kelly, I was able to pull a Bank of America statement that showed the account had even gone down to like $5,000 during the marriage. So it was impossible for him to have that money. Now, Justice Guerra, when you're referring to an E-Trade, I do think he may have tried to argue like, oh, I transferred some of the money from Bank of America to E-Trade, but he certainly didn't prove that by clear and convincing evidence through the records, period. I know for certain of that, but he may have made that point, but I don't recall. I remember the Bank of America. Some other quick points that Ms. Smith raised at the beginning was that she mentions the math. The only math that was ever offered at trial was Ms. Kelly's. There was no competing argument of any kind of calculations being made. Like, I mean, I don't remember exactly what specific example she gave on the math, like, but there was no ruling by the court that my client, Ms. Kelly, would get 60% of each individual asset. It was 60% of the overall estate. I don't know where she's getting her numbers. There was no request for additional findings of the math used by the court or anything like that. So
where is the statement that she was getting 60%?
It's in the findings of facts and conclusions of law that she's going to get 60% of the marital estate. The only specific asset, no, that she was just going to get this 60% of the overall pie, if you will, not each individual asset.
But do you concede that that's not exactly what happened in the end? That she did award greater than 60% of some assets and maybe less, but didn't dip below, I don't believe, 60% on different assets.
Right. You know, she definitely, it was not 60% of certain assets. She factored in the whole thing, and that, you know, my client had liabilities. She had to, her attorney's fees. She had, you know, on her spreadsheet, she had several liabilities that were awarded to her that would be factored into the 60% division. She wasn't just awarded 60% of the assets. She was also, it was all of it, the whole pie that she got 60% of.
What's your response then to,
go ahead.
I was just going to say, what's your response to your opposing counsel's argument that if you looked at the entire community estate, that she actually ended up getting awarded far more than 60%?
I don't think that's accurate, but I don't have a.
That's why I'm asking, what's your response to that? Do you believe that it was 60% across the board when you take the entire?
Yes. Yes, it was, because I drafted it. It's 60-40.
I had a question on the trust. Here, what is the best evidence for a trust? That, I mean, I've seen, you know, what you're relying on to say that there was a trust of some sort floating around out there. What is the best evidence in the record, if there is any, for a trust that could actually be construed as community property?
Really, it is only what's in the record, period. There's no documents.
There's no document
other than the one that got admitted, but it's Mr. Kelly's statement that was an issue. That was an issue. The divorce, it was an issue at trial, that there was this reference to this asset, and he was concealing it. He was not disclosing it. And I mean, it's black and white that it was an acknowledgement. So the court did what she could in that situation. What else could she do?
But do you agree that if it was going to be an inheritance of his, that would have been his separate property?
I do not. If he had proved by clear convincing evidence and under the Constitution of Texas that he would have inherited that money came from his parents and that it was inherited, of course, but he had to show that and prove that and testify to it just like anybody else that wants to claim a separate property interest in something. The community property presumption prevails.
And his parents are living currently, right?
I don't know. I think at trial, he testified that they were living.
Okay.
Yes. So, and I believe Ms. Smith also made a statement at the beginning that the trial court ignored his separate property except for his house. Well, that's not true. We had a stipulation. It's in the record that, we prior to trial, we agreed that certain things were his separate property. One of which was the house. Another was a portion of the pension that we applied the formula to. So it wasn't ignored, but it's not the court's responsibility to prove what is his separate property. It's only Mr. Kelly's burden to prove what is separate property. And he has to do that. He has to put that effort forth because the community estate has the benefit of a presumption. And it's a high standard, clear and convincing evidence. It's not just some evidence. He had to come in with something, and the courts like to give people separate property. He didn't even come in with a reliable statement from a financial institution. He came in with a sketchy spreadsheet that only came from him, and that he had Miss Osina is the same thing as Mr. Kelly in this situation because she said she's relying on what he told her about that this came from Transamerica when there was no indication it came from Transamerica. And his credibility at that point was shot. It came out in testimony just as an example that he had a secret account with his brother that I didn't know that until trial. He lied about all kinds of things. I think that my time's up.
Okay, thank you very much for your argument. Now I'll return to the appellant.
Thank you, Your Honors. First of all, Justice Kelly had a question about where is it in the record that there's 60-40 community, and that's in the finding of facts and conclusions of law number 7, which is at the clerk's record at number 619. And before I reach other issues, I'm afraid that Mr. Kelly's counsel has misspoken. She talks about how that there were absolutely no documents of anything about the severance, and there was really nothing to base it on. And that's because there was this trial stipulation as to who got what from the severance. If the court looks in the record on the clerk's record at 186, there's a trial stipulation. As the court well knows, when you have a trial stipulation, you don't need to bring a lot of evidence. You don't need to bring a lot of documents. That cuts right through everything. The counsel also mentioned that there were no documents to support what Mr. Kelly's expert said. She's misspoken there as well, because what the expert testified to is before trial, I believe it was in January of 2018, she produced a report which was based on all the financial documents that she was given. Was she given financial documents by Mr. Kelly? Well, of course. That's how the expert gets information. She gets copies of documents from all the various bank accounts, all the various 401ks. And that's what she was basing her preliminary report on, which she talked about during her testimony before she got to trial. At trial, back then, what Mr. Kelly had were bookends. He had a statement from October 1, 2012, which was the month before marriage. And he had a statement from November 30, 2012, which was right after the November 6 marriage.
And those both came into evidence?
Those did not come into evidence, directly into evidence. Those are what the expert based her preliminary report on. By the time it was closer to trial, they had inquired of Transamerica and said, look, we only have these two bookend statements to show before and after. Can you get more precise with us? Can you tell us what it was on the day that they got married? And it was respondents 8B, which came into evidence, which the court found credible, which the court allowed her to testify to as well she can. And as we talked about at length in our reply brief, that was the precise number. And that's one of the reasons the court will see some estimations of 213,000 and 213 and change. And that was because we had bookends before a week or two before trial, when we actually had a document that said on that date, here's what it was worth.
All right, so can we move back to the severance? So is your best argument against the Henry case just that it's distinguishable? You have any other case law that you find that's more analogous to this situation?
Your Honor, I'm so glad you asked that, because that's where I was going next. And that is that we really don't have a lot of clear guidance. What I'm saying is it's distinguishable from those cases because those cases are kind of fuzzy on here's when it's severance that is separate property and here's where it's not. So when this court sends the case back, we would so appreciate some guidance. And for this court to make that hard call, because I looked all over Texas and no state court has actually made that precise decision under the facts that we have, where the company had already calculated by years of service. So we need some guidance from the court on that and for the court to make the hard call if it will. And I certainly disagree with, I thought the question that Justice Ferris asked was so appropriate. How about if you got a severance the day after they got married? Well, it certainly wouldn't be equitable and it certainly wouldn't be appropriate for her to get 21 years of severance times however many weeks if they'd only been married for a day. And so certainly we would love some guidance from the court on that, since Henry and Worrell are kind of fuzzy and they only say, well, there's only some evidence that it was based on past performance. We have a really different scenario here. We have a clear statement from the company that's saying this is how we're basing severance. So, Your Honor, I see that my time is expiring. And so one of the things that might assist the court, when I was preparing for oral argument, I had to crunch the numbers. So with the court's permission, I'll file a post-submission brief that's basically a chart of here are all the numbers and here's what's wrong with them. Thank you, Your Honors.
Feel free to make that submission. Cause number 0119000580CV, Kelly versus Kelly, is submitted. Thank you for your time.
Thank you, Your Honors.
We're now moving on to 01-21-00015-CV Weeks Marine Inc. versus Mario Carlos. We have appearance of counsel on behalf of the appellant, please.
This is Kent Morrison, Your Honors, on behalf of Weeks Marine.
And you have been allotted 15 minutes total, and you're reserving 3 minutes for rebuttal.
Yes, sir.
And who have the appearance of counsel on behalf of the appellee?
Yes, Your Honor. This is Chris Levitt on behalf of Mario Carlos.
Okay, thank you. As soon as the clerk moves Mr. Levitt off the screen, we will hear from Mr. Morrison. You may proceed, Mr. Morrison.
Thank you, Your Honors. Understanding the factual underpinnings of this matter is critical to resolving the jurisdictional issue that's before this court. And there are two sets of facts we believe that are important to focus upon. And before I launch all the way in, of course, if the court already has questions and has directed things that they want to ask me about, I welcome that completely. but I'll go forward until somebody tells me otherwise. But there are two sets of facts that are important: the general facts and circumstances surrounding Weeks, who it is, what it does, where it is located, and its employment of the plaintiff. And then second, more importantly, those facts and circumstances surrounding the incident at issue. Now, the general facts are undisputed. Weeks is a New Jersey company with its principal place of business in New Jersey. Nobody is disputing that. Plaintiff was first hired by Weeks nearly 20 years ago. He has come in and out of employment a couple of times. I'll explain later why that is not important, but he has been with the company for a very long period of time.
Where did he reside when he was first hired?
Texas, Your Honor.
And how did we find him?
I can't tell you that. Well, I think plaintiff actually set it forth. He was with the predecessor to Weeks. Weeks purchased a dredging company that the plaintiff was employed by, and he came over with that company when it was absorbed into Weeks.
Did he come over, or I thought actually he was recruited by Weeks, and he wasn't? It didn't sound like that was what happened.
Well, there is. I guess recruiting is one way to say it. Yes, the employees who were there were asked to submit applications to remain with Weeks, and had the opportunity to remain with Weeks. Now, I'll discuss later why I don't think recruiting is important and why you have to weigh different things in the recruiting process. But yes, it is fair to
say. Why don't you cut right to that? Tell us why recruiting is not important.
Well, let's talk about that for a moment. There are a couple of general jurisdiction has generally been it's been accepted by plaintiff that general jurisdiction isn't there. We have the paradigm forum focus, and the paradigm forum focus in this instance cannot possibly be met. So plaintiff's counsel is focused on specific jurisdiction. And when you look at specific jurisdiction, the factual underpinnings, the real factual underpinnings to this case, the bolt that hit him in the face, the falling off the ladder, all of that happened in Louisiana. So right. He changed course late in the game after two earlier petitions to say, no, the real basis of our claim is the hiring, screening, and training of the plaintiff. The plaintiff was hired in Texas, should have been screened differently in Texas, he and his coworkers, and should have been trained differently in Texas. Well,
what about, sorry, and more to that point, what about the long arm statute? How does that apply here?
Well, I think the long arm statute is subject to your general propositions of jurisdiction. The long arm statute is really a mechanism by which to serve a company, and it talks about what the service issues are. How and when how do you serve somebody who is doing business in the state? It does not supersede either general or specific jurisdiction. You have to get through general and specific jurisdiction. You have to have that fundamental fairness, that baseline of a presence in Texas for purposes of this claim.
So what is the test for specific jurisdiction as recognized by the U.S. Supreme Court and the Texas Supreme Court?
The substantial connection test, Your Honor.
What is the substantial connection test? If you could phrase that for me, please.
So the factual basis for alleging specific jurisdiction must be substantially related to the basis of the action. There must be a tie between, under specific jurisdiction, the facts underlying that claim and the state, here, Texas.
Have you looked at the case that recently came out from the United States Supreme Court, Ford Motor Company versus Montana 8th Judicial District Court?
I have, Your Honor. Do you believe that changes the paradigm?
Well, I believe it clarifies the paradigm, nothing else. Focusing on the phrase that the plaintiff's claims must arise out of or relate to defendant's contacts with the forums. And the court was very blatant and explicit in saying that it is a disjunctive test. So by phrasing it in terms of substantial relationship, you're actually twisting that test, because the question is, it seems to be here, does the claim relate to Weeks's contacts with the state?
I think, if the court feels like I was trying to pull a fast one, no, I'm not. I agree with you. There are two ways to look at it, but under the analysis, both times, you have to look at a substantial connection. That applies in both instances. The idea of some substantiality to the connection between those facts.
Well, the word is relates to. So we're looking for a relationship, not necessarily a substantial connection. And those words will be defined differently in Black's Law Dictionary and in Webster's. So let's focus on the relationship between Weeks's contacts and Carlos's injuries. So what were Weeks's contacts?
So fair enough. Those contacts, and I think they have to be looked at not in a vacuum, in the totality of the contacts and where those contacts were the hiring, according to plaintiff, the screening and the training. Well, the plaintiff would like you to focus solely on the state of Texas, on the hiring. The hiring happened at best on 3 discrete occasions well before this incident. The underlying facts of this incident don't have anything to do with the hiring. They have to do with what happened out on that dredge and out on the.
Well, let's see. Now you're shifting a little bit. Does it relate to the hiring? I mean, Carlos's entire employment relates to his recruitment and hiring.
Well, Your Honor,
there's a relation there.
I've always been careful. I don't want to argue with a judge, but if you look at it a different way, if the mere test is, and I think you have to look at the entire, all of the existing case law from Daimler to Walden, so on and so forth, that started to restrict the idea of jurisdiction. If it is only related to, in what circumstance does a citizen of Texas not have the ability to create jurisdiction against a company that has any relation to them at all? In other words, every Texas employee of a company that is based outside of Texas is a jurisdictional being in and of himself, because it has to relate to him in some way. He's hired by the company. He works for the company. So if the
Except in this case, sorry, wouldn't you say, I believe there was some evidence of ongoing training every year, which happened in Texas as well.
Very minor. And that's why I think that part of the test, when you look at the totality of the case law that's out there, is to measure that. There was very little training that was going on in Texas in comparison to everywhere else. 86% of the training that the plaintiff received was in Louisiana. Only 12% at most was received in Texas. And there has been no evidence that the exact 12% that he received had anything to do with this Bolt incident or the latter incident. It's absent. There's nothing there that suggests that there is some linkage between that 12% that happened in Texas and the incidents at issue. And if the counter argument then becomes, well, then you should have trained him in Texas. Well, there is no limitation on jurisdiction. Any individual in Texas that works for a company elsewhere and spends absolutely every second of their time elsewhere working for that company could bring them into Texas.
But that's not the facts here, right? He received training here. He gets drug tested here. He got his medical treatment here. He has drug screening here. All these things happen in Texas.
Well, Your Honor.
So his employment relates to the process of hiring him and the process of training him.
Well, when you look at the case law, and as you said, there were 2 aspects to the substantial connection test. There is also the last component of the test, which is even if you have a substantial connection under your analysis related to, it must not offend the traditional notions of fair play and substantial justice.
Did you challenge that?
I'm sorry?
Is that challenged here? And is that issue before us?
I believe it is. The entire concept of personal jurisdiction is. And we've addressed the issue of traditional notions of fair play and substantial justice. I don't believe that you could say in these circumstances, when the vast majority of the contacts are outside of Texas, the small, to me, relations to Texas are minor in comparison to Louisiana, especially as regards these 2 specific incidents, that you can say that the traditional notions of fair play and substantial justice would be satisfied in this circumstance. The vast majority of everything involved in this case is about 2 accidents that happened in Louisiana with a company that had a division out of Louisiana for actions and activities that were in Louisiana. It was the equipment that he was given, the place that he was worked, whether he had supervision at that place in Louisiana, who was supervising him during that period of time, what that person told him to do. On both of those circumstances is all in Louisiana. And if the test is what you are suggesting at this point, it means that any accident at any time involving anybody from Texas to
I don't
me.
think anybody's saying any accident, any time. I mean, 12%, that is a substantial percentage. We're talking about the training. You said only 12% occurred in Texas. Well, that is a substantial, non-trivial amount of the training that occurred in Texas. Why can't we consider that in trying to figure out whether the injury relates to that contact?
I think you can consider it, Your Honor, but I would suggest that 12% is not substantial, as that word is defined. Substantial means something significant, and 12%.
Okay, well,
which
right.
means.
All right, I disagree that substantial has that meaning. Substantial basically means measurable, that something is there, non-trivial, non-negligible. Or the opposite would be insubstantial. This is not insubstantial. This is 1/10, more than 1/10 of the training. So if you have any case law that would suggest that 10% is trivial or should be entirely disregarded by this court, please forward it. Are there any other questions from the panel?
Not at this time.
Okay. Thank you. Thank you for your argument, Mr. Morrison. We'll see you in a few minutes. You may proceed, Mr. Levitt.
May it please the court. And Judge, I have an outline I'm gonna get to, but I do want to address something that y'all, that counsel for the appellant and this court was just discussing, and that's the training. And Weeks Marine's counsel said there is no connection between the training and the incidents, and I want to address that first because I think that's important, and frankly, I don't think that's right. I don't think that's true. With the evidence that's in the record, and specifically I'm referring to the affidavit or the declaration provided by Weeks Marine by Teresa Olivio. And if one were to look at that training, in detail, I think what the court or anybody else would find is that it indeed relates and it indeed connects the dots about what we're talking about. More specifically, Mr. Carlos received hand tool training in Freeport, Texas on March 14th, 2016. And I'm reading from tab 4. I'm relating to what I'm talking about is in tab 4 of Ms. Olivio's declaration, the training records. Additionally, Mr. Salazar, who I respectfully submit has as large, if not a larger role in this than Mr. Carlos, received fall protection training in May 14, 2014, and that was in Bayport area. In February 14, 2016, received task safety analysis, which is like, how to plan a job safely in Freeport, Texas. And importantly, in May 7, 2014, received inspection of mobile equipment training. And I think maybe the most salient point is that Mr. Salazar, the supervisor, was not present for the hand tool training on March 14th, 2016, wherein Mr. Carlos did receive that training. So, I'd like to address that point first, that there is evidence, it is in the record, it was actually provided by Weeks Marine. But what we have been talking about is not purposeful availment or the fair play and substantial justice, but the middle prong, which is the relation to or substantial connection, Judge, the substantial connection tests. And I think to look and determine, whether that exists in this litigation, the first analysis that needs to be made is look at the claims brought by plaintiff. And the first of those is unseaworthiness, which is a maritime claim. And, kind of the rough definition of that is, the owner of a vessel is under an absolute non-delegable duty to provide a safe, seaworthy ship, with a complete and competent crew. Jones Act negligence, maritime negligence, essentially the same thing, requires the Jones Act employer to provide a reasonably safe place to work and keep that vessel in a reasonably safe condition, which includes a properly trained and competent crew. So both of the claims relate to a trained and competent crew.
Is there any evidence in the record about what percentage of Weeks Marines, say Louisiana workforce, was recruited in Texas?
Not at this point, Judge. The declaration provided by Mr. Carlos speaks to the number of employees that are hired from the Rio Grande Valley. So that's there, but there is no analysis as far as I can tell, as far as the total number of employees, at Weeks Marine that hail from Texas. Although I would, this is in our pleadings, and I respectfully submit also our response to the special appearance. A focus of this litigation is going to be Weeks Marine's hiring practices in Texas, and the reason so many of their employees for what they allege to be a corporation run out of Cranford, New Jersey, come from the Rio Grande Valley in Texas. And I can, from personal experience, I can tell you we have, all of our clients at 2 Weeks Marine are from the Rio Grande Valley of Texas. It's a substantial amount. In fact, what is part of the record is the Landa case against Weeks Marine, which is currently pending in Starr County, is another, he's a Starr County resident. It's a substantial number, and I would respectfully submit will be a focus of the litigation.
But you will concede that at least for the claims in this case, they're all, happening in Louisiana waters, on vessels that are in Louisiana waters, and that really Louisiana then would have a very close connection to the incident.
I will concede both of the injuries occurred in Louisiana. And I would respectfully submit that's not of great importance, because the test is not, specific jurisdiction is where the injury occurred. If that were the test, I'd lose, right? Because the injuries occurred on a vessel in the waters off the coast of Louisiana. Now, what the argument that Weeks Marine has made is that with the training, the fact that it occurred in Texas is just kind of fortuitous, because it's a ship, it floats, it moves, the training is provided on the vessel. I think if the court were to accept that as true, or if the court let's just take that at face value, doesn't that equally apply to where the incidents occur? Isn't just a mere fortuity that they happened in Louisiana? Because they're on.
You have to have jurisdiction somewhere.
Fair enough, and absolutely. Well, the plaintiff would hope, right? So that's the test is, where does this relate to? And for the specific maritime claims at issue, these are not state law negligence claims. These are unseaworthiness and Jones Act negligence claims, which specifically relate to a competent and well-trained crew. And so the analysis for those claims in this instance goes back to where are these people coming from? What training did they receive? Were they properly screened? Were they properly hired?
Does that make this one of those cases where the jurisdictional facts are so intertwined with the liability facts that the jurisdiction should be carried with the case? Or do we have enough facts before us now to resolve that issue?
That may be a question that's above my pay grade. I can certainly see that where a more well-developed record would help this court make a more accurate finding. I think that maybe that's always the case, but I certainly think in this case.
A question. We've been talking about how much training is really enough to meet this substantial standard to bring something of substance. If he had received just 30 minutes of training in Texas and the vast majority of his training elsewhere, would it be your position that you should win here? How much is enough?
I think it's a more accurate analysis to look at not how much but what training?
Mhm.
And I would respectfully submit here that you have hand tool training, which directly relates to an impact gun. You have fall protection training, which directly relates to work on a ladder and a fall from a ladder, all occurring in Texas by Weeks' own admission. So, I guess if it's a 30-minute training session, what we're talking about, but it directly relates to the accident that ultimately befalls the plaintiff, then perhaps that is enough. And maybe, if it's specific enough, that is enough, and that is enough to win jurisdiction. But just as a general matter, saying is 30 minutes enough? I think if it's unrelated, who knows, maybe not. But for the facts in front of us, with the specific kind of training that we know occurred in Texas, I would respectfully submit it is enough. I'll revert back to my outline. So for these maritime claims and how connected they are with having a properly trained and competent crew, the focus of the litigation will be, where are these folks hired? Were they screened? Why were they hired? And did they receive training? And another issue that Mr. Carlos addresses in his declaration and is addressed in our response is the yearly testing that Mr. Salazar, Mr. Carlos's employer, that we're obviously alleging is the cause of his injuries, incurred yearly. Now, Weeks Marine has presented no evidence or presented no response to this issue of yearly testing that Mr. Salazar, who is the supervisor, did every year in Texas. There's been no challenge to that, and Mr. Carlos has provided evidence that he was with Mr. Salazar not every year, but many years when this testing would occur, and would all occur in Texas. And obviously, the reason that's important is because if that's being done sufficiently or not deficiently, if an incompetent crew member or an untrained crew member, gets filtered out or gets caught, or that gets rectified. Unfortunately, no, in this case it did not, because both of these injuries did occur.
Could I interrupt with a question that I believe that Justice Kelly had for your opponent? Have you had a chance to look at this Ford Motor Company U.S. Supreme Court decision?
In all candor, I read an article about it that an appellate firm wrote. It was like a CLE, so I am aware of it. But I would be lying if I said I read the case.
Well, it came out well after the parties completed the briefing, because it does seem to clarify, if not shift, the test. If both parties could submit a brief discussing the case and how it affects your relative positions within 10 days of submission, and let's cap it at 2,500 words, because we're really just discussing one case. That would probably assist the court in resolving this case. But you may proceed.
Roger that, Judge. So for the related test or substantial connection test, obviously, to connect the dots, it is the training that we know occurred in Texas, testing which occurred in Texas, the types of injuries, types of accidents that occurred, and more importantly, the fact that Mr. Carlos's supervisor, Facundo Salazar, was similarly recruited out of, hired in Texas, tested or supposed to be tested yearly in Texas, and as I think we described him in our moving papers, was part of the instrument of negligence that ultimately injured Mr. Carlos. And when you compare that to some of the cases on these issues, such as Moki Mac or the Brokaw case, Brokaw versus Anderson, you see a connection that is much stronger than any of those cases where the instrument of negligence is actually also from Texas, hired and recruited and supposedly trained trained on these incidents in Texas. I do want to I'm sorry, go ahead.
Oh, I was going to ask, what's your response to opposing counsel's argument that the long arm statute is for service. It's not something that we look at for jurisdiction.
So, as I understand it, and I will admit I'm probably the least well-versed person on jurisdiction in this Zoom room. But I understand it. Jurisdiction is a three-prong analysis. The first is purposeful availment. Second is substantial connection or relatedness test. And the third is whether this meets with fair play and substantial justice. I think the long arm statute relates, if I'm not mistaken, to the purposeful availment prong. And so, the analysis of, has Weeks Marine purposely availed itself of Texas, and does Texas, does its long arm statute allow it to be brought within its jurisdiction based on that? And I would respectfully submit the answer is clearly yes, considering Weeks Marine has filed a case in federal court in Texas, in the last 6 months related to a Jones Act seaman, in addition to the other evidence we submitted along with our moving papers.
How were other lawsuits relevant to whether there's jurisdiction in this one?
Well, for the purposeful availment and the long arms, and the purposeful availment and the fair play and substantial justice prongs, I think it is relevant because I think what the plaintiff needs to prove and has is that Weeks Marine has availed itself of Texas law. As it relates to the second prong, the relatedness test, admittedly, I don't know that it has a lot of relevance to the second prong, but it would for the first and the third.
That say that we can consider that?
For the first and the third prong?
Yes, other filings and other.
For whether Weeks has purposely availed itself of Texas, I believe that's true. As it relates to the relatedness or substantial connection test, I don't think they can be. I don't think they're relevant. I'm sure the court can do whatever it wants, right? I mean, it can consider whatever it wants, whether it takes into account. But I think there are cases say that those are not relevant.
Any other questions from the panel? Thank you, Mr. Levitt. Now we will return to Mr. Morrison for 3 minutes of rebuttal.
Thank you, Your Honor. Couple of quick points. Weeks can, of course, avail itself of jurisdiction in Texas where specific jurisdiction exists for a claim. It can exist in certain claims. We're just saying it doesn't exist here. And Mr. Levitt is aware that in that case that they referenced, it's actually a case that he and his partner filed against Weeks, and Weeks filed a limitation action as a prophylactic measure on that case if they lose jurisdiction. So it doesn't mean that specific jurisdiction exists here. Your Honor, I wanted to point you to some language that I think supports in part what I was saying earlier about there being some sufficient arising out of or related to language. When you look back at the Ford case, the court was cautious to note that the test they were laying out contemplates that some relationships will support jurisdiction without a causal showing. That's in quotes, Your Honor. But the majority also cautioned that it, open quote, does not mean that anything goes, close quote, and that relates to, open quote, incorporates real limits as it must adequately protect defendants foreign to a forum. So again, I think in order to do that, there has to be some concept of proportionality. When Mr. Levitt talks about the training, as you'll note, he's pulling training back from 2014 and 2016. Well, this accident didn't happen in 2014 or 2016. And when you have an employee like we do, Mr. Carlos in Texas, you are going to have all sorts of training over time that may from time to time be in Texas.
Are we delving into the merits of the case now and not just the sort of the naked jurisdictional issue?
I don't think so. They were allowed to make their allegations, and we were allowed to put on factual evidence to contradict that evidence to show that the related to or the substantial connection wasn't significant enough to establish specific jurisdiction for this case. I'll finish with this, Your Honors. When you look at all of the evidence, when you look at this case and what it's about and where it occurred and what happened and where the vast majority of the training occurred, and when you think about the fact that all of the hiring, all of the screening, all of the decisions about training come from Louisiana or New Jersey. There is not.
Do you have evidence that that specific, the hand tool training and the, falling training or ladder training took place elsewhere besides Texas after the 2014-2016?
I do not.
That Mr. Levitt pointed out.
I do not have it in the record. It exists because it happens on a regular basis, but I do not have it in the record, Your Honor. But when you look at all of that evidence together, Louisiana is where this case belongs. Thank you for your time. Appreciate all your very tough questions of me today. And we will brief the Ford Motor Company case as described.
I saw Mr. Levitt's reaction. I just want to make sure you got that request from me as well. Thank you for your time. Cause number 01-21-00015-CV, Weeks Marine Inc. versus Mario Carlos is submitted, and court is adjourned. Thank you very much.
Thank you.